state where secrets hide. In Tampa Street, she seeks out lies. With a sharp eye, she'll reveal the truth. Justice calls and she pursues. From county jails to hallowed courts, she finds truth where they distort. Fearless heart and mind so keen, Sam unravels tangled seams. The truth is buried deep in files. Fairness is what they try to hide, but Sam prevails. She's got your back. With grit and grace, she never lacks. Uncover lies and play no games. From jails to halls where verdicts lay. Truth her compass, come what may. Footsteps echo in the night. She chases justice with the light. A warrior for justice for all. She won't stop when she hits a wall. Florida P.I. Sam is her name. Uncover lies and play no games. From jails to halls where verdicts lay. Truth her compass, come what may.
Hi guys. Good evening. Happy Saturday. Happy Saturday, everyone. Guess who I have? Guess who's back? It's Scotti Sinardi. Unmute yourself, Scotti Sinardi.
Hey everyone.
Hello. I missed you guys. I'm so sorry. I had a little week off of YouTube. I apologize for that, but we're back. I'm so happy to see everyone. Yes, let's say hi to everybody in the chat. I'm sorry. I've been preparing for this stream. It was already prepared, and then this morning I came across some new stuff that I wanted to cover, and we've been working on that all day. So I'm a little discombobulated, which should surprise no one at all. So thank you, Tanika, for redirecting your members only live on over here to Florida PI Sam. I am Florida PI Sam. I am a licensed private investigator in Tampa, Florida. However, I specialize in criminal defense, and I went to law school as a midlife crisis. And you see with me here is the young Scotti Sinardi, who is a young, and I emphasize young, criminal defense attorney who is kicking ass and taking names. Thank you for coming on, Scotti.
No problem.
Looks like you're at the jail. You're not at the jail,
Nope.
Are you, sir?
No.
Okay.
I'm on my back porch.
Okay.
Enjoying the 40 degrees.
Yeah. Well, it's nice out right now. Yeah. So Scotti has twin girls, and they are 4 now. Did they just turn 4, right?
Yeah, 4 on January 16th.
Okay, so this is a night free of twin 4-year-olds, which is how he's able to join me here sort of at the last minute. So welcome anyone who is new coming over from Tanika's stream. Let me go over and say hey to everybody. I see my mama and my daddy. Hi, therapist, C. Morales, good to see you. Tony Tim, welcome. Barry Adams, here to check in for jury duty. Afton Forad, nice to see you in your picture. Mel, how are you doing, Mel? So glad that you seem to be doing well. Hi, Ashley. B. Michigan, welcome. Hi, Carolina. Good to see you guys. So I want to just say give a shout out to my stepmother, Susie, who I believe is in the hospital currently. We are all sending you our very best healing vibes. So we hope for a quick recovery, or at least a complete recovery at this point. Because, well, hello, Barbara Ellison. It's been a moment. Yes, everybody put some pink hearts in the chat for my stepmom, please. She could use the healing energy right now. Okay, so hi. We've had a week, huh? Separately, but we've both had weeks.
Yep. Good and bad. I mean, and that's usually how it goes. Some days worse than others.
Right. So, let's see. I did a lot of reviewing discovery in one of your cases, and then I went out to my absolute favorite jail, Pinellas County. Pinellas. I'm from Ohio. I suppose it's Pinellas. To see, I am not lying, a 14-year-old charged with first-degree felony murder of his sister. I spent 2 hours with this outstanding young man. I showed him video footage that would make most people cry, and he was flat. No affect, no reaction whatsoever. I explained to him all the things. He's excited to go to trial. I'm like, this is, do you understand how trial works? And he's like, yeah, we get to watch a YouTube channel called something I'd never heard of. And I thought, oh my God, we're in trouble. Okay. So I explained, tried to explain to him all the things. And I said, if you'd like, I can come back and bring you, your charges and match that with the jury instructions, with the model jury instructions, so that you can see what it is that the state has to prove in order to find you guilty, right? And I explained to him the whole thing about, like, the defense doesn't have to actually put on a case. They just have to create reasonable doubt, and tried to explain that to him. And we're going to talk about reasonable doubt tonight, because I think we're learning that, like so much in today's world, it's just not really clear. So he says to me, he kind of shook his head, and he nodded his head. And I said, is that a yes or no? He goes, I don't really care. I said, okay. So I guess I won't be having to go back out to that jail. Thank you for all the pink hearts, you guys. I really appreciate it. She will catch us on the replay. Hey, there's the Squeegee of Justice. So nice to see you. Yeah, reasonable doubt, Barry Adams, is a lot harder. We put a lot of time into the presentation for reasonable doubt tonight, and it is going to wrap our little series I've been doing on the jury for now, and we may come back to that. Did you get to see any 14-year-old murderers this week, Scotty?
Nope. One of my 15-year-old murderers is in solitary for causing problems at the jail. So, yeah.
So first he escaped custody one time, right? And
yes.
Then he flooded the jail or his cell.
Yeah. So.
Yeah. So, guys, the future is so
the
bright.
Juvenile pods are far worse than the general pops, so I've heard. Kids terrorizing each other.
Yeah. Where would
we had a client that said that he actually enjoyed being in adult gen pop more than he did in the juvenile pod. So
right, and he stopped getting in trouble once he was moved over to the adult population. So I think that's really interesting, that it's kind of like oh my God, what is the book? That old book. the boys stranded on the desert island. I taught it in high school. I can't even remember what it's called now. It'll pop into my head at some point, I'm sure. Hi, welcome, Texas Redhead. Yeah, glad to see all of you guys. So, Scotti, you're busy all the time, right? I talk to you because you're in the car a lot going from county to county, which you need to stop doing because all the counties besides ours
wrapped up.
Lord of the Flies. Thank you. Yeah, thank you guys. Lord of the Flies is what I no, Scotti does not have a YouTube channel. I think you can find him on the TikToks though. You have TikTok, don't you, sir?
Yeah, TikToks. I haven't posted in a while. I got to get back into it. I do use TikTok.
So you can find him on TikTok. So we have seen, I don't know how much of Karen Read you've been following. But Judge Beverly Canoni seems to have, oh, hi, Tanika. Welcome. Thanks for coming. Thanks for sending your folks over here. You're lovelies. We really appreciate you. So in Karen Read, it appears very much as though Judge Beverly Canoni is biased. I think most people might agree with that. Right? She's really hard on the defense and does not rule nicely towards them. And you ran into a little issue with a judge. You said it was your 4th time with this one particular judge. You want to tell the folks?
Yeah, I just think he doesn't. So my first run-in, I don't know if this is my 3rd or 4th. I lost count. First run-in, he just was disrespectful. He just issued a capias for my client, which is an arrest warrant for not showing up to court. Had to get that resolved. Didn't want to resolve it. I had to drive to the bondsman office and kind of pull the bondsman to court. Thank goodness the office was up the street. He showed up, testified to the judge, and said, I don't have an issue reinstating the bond. Luckily, he did. I had an issue with him Monday when I was trying to get another hearing date and said that I intend to file a motion to dismiss, and he kind of presumptively stated that he would deny it when he said, what are you going to do when I deny the motion? And I said, I guess we're setting a trial. And he said, okay, that's what I wanted to hear. And then I was covering for someone in court that day, another attorney, another colleague, and he pulled the arrest warrant issue again. Had to have that attorney drive to court, told that attorney, I apologize for making you drive all the way to court. Just want to make sure that you're going to be the attorney of record on the case and not Mr. Sinardi. And then on, I want to say Thursday, it was a first pretrial, which is just the first hearing of status. I was ready to set the case for trial. It's a 15-page police report. There's no discovery to the case. Judge didn't like hearing that, wanted to set it for trial within 2 weeks and said no plea negotiations, no offers, no longer available, and was upset I was trying to set a case for trial. So
I mean, it's like problems. You get it from all sides, right? The clients are complaining for every stupid reason under the sun. Their families are interfering. The state's attorneys are not cooperative. And then you have judges that just make everything so crazy. It's just awful. And no, I don't believe there is a remedy. We're kind of at the mercy of judges. You know, the remedy actually is that
you got a coin flip to try and get him recused, which is throwing off the case. But if you don't get him recused, then you're stuck with them, and then they're going to be even more mad that you try to get them thrown off the case. So
right. Well, the answer is don't take any more cases in that circuit, please, and thank you. Right. So it'll be for less stress and less driving too. Right.
Yeah, I'm kind of an hour away from every other county.
Yeah, it sucks. It just sucks. Yeah. All right. So Tanika is talking to Chris and saying the discovery drama is unreal. This judge is so patient. So Tanika, that is exactly what we're going to talk about first. I'm interrupting my regularly scheduled jury programming to talk about the Shanna Gardner Jared Bridegan case for a moment, and not the actual case itself, but about this discovery situation. And so what happened was this morning, I have not been on YouTube much at all this week. I just have had other things to do. I can't be in chats all the time because somebody has to buy the cat food. And if I don't work, I don't get paid. And then Henry doesn't eat, and it's a thing. So I clicked on a video that Child TV Live did yesterday covering a case management conference in the Jared Bridegan channel or case. Sorry, guys. So for those of you who don't know, Jared Bridegan was murdered by, well, I think his wife hired someone to do it, right? Tanika's 2 cents, my friend Tanika, she's got episodes up with the case background, which I've watched a couple of times. And of course, with all of the other cases that are swirling around my head, I have it all mixed up. But he was a Microsoft exec. She is a multi-level marketing trust fund baby. There's a lot of shenanigans. He is now deceased. She is going on trial with a co-defendant. Like I said, I'm not here to actually cover the details of the case. What I was interested in is what the case management conference covered yesterday. But be sure and check out, hey, Drunky the Bear. Hi, Ashley. I'm a private investigator in Florida. I work in criminal defense. This is my friend, Scotti Sinardi, who is also a criminal defense attorney. We are located in Tampa. I work on some of the cases like Sarah Boone that you guys watch on YouTube. And on this channel, I try to give you a little bit of background, a little bit of behind the scenes of defending the indigent. What happens before you guys see the trials, right? Because there's a lot in between the crime and, and the trial. So I come on here and talk to you guys and try to bring you stuff you haven't seen, but incorporate it into what you're seeing on YouTube. And I have a law degree, but I do not practice the law. So hopefully that helps. I'm here every Saturday at 7:15, except for last Saturday because life. So we're going to talk about this hearing that happened yesterday. I think it was yesterday. I honestly don't know. Again, Tanika, and then Trial TV Live, whose footage we're going to use. Chris breaks it down at the beginning and the end. I want to talk about why they were there. So you guys have heard me complain endlessly, because I swear that's all I do is come on here and complain. You've heard me complain about discovery and the problems we have with getting discovery from the state. And I also did back a couple of months ago, and Alexis will put links in for you. And we have playlists on the channel. I did cell phone behind the scenes of like cell phone extractions. So I've done some pieces of this along the way, right? Hi, Fala. It's so nice to see you. I create these series on the channel where I dip into a subject and cover it, and then I push pause on that and move into another one. So right now we're wrapping up our jury series. It doesn't mean we're never going to talk about the jury again. It just means that for this little bit, we're done. But I'm interrupting my jury piece to talk about this evidence, or this case management conference yesterday. So, when law enforcement extracts a cell phone, so when they take whoever's phone and they plug it into the Cellbrite physical analyzer device and pull the contents of that phone off, that can be, would you say, hundreds of gig?
I've seen it up to a terabyte.
On a phone?
On a phone.
Okay, I know.
Maybe more than one, but I've gotten a hard drive with worth a terabyte, and it was just phone data. Maybe
Yeah,
one,
that's crazy.
maybe a few phones, but nonetheless phone data. So
Right. So the files are gigantic in terms of how much space they occupy, and particularly for phones, tablets, computers. If
entertainment centers.
oh yeah, I just learned about something new today in this hearing that I had no idea about. If so, oh my god, my words are failing me. It's supposed to be provided to us like in a package, right? They even call it that. What to do with the account package, and it will have the Cellbrite reader. It will have a PDF of like, here's how you use this. It will have I think it's called UCAE, which is like the raw extraction that somebody above our pay grades, like John Sawicki, can like plug in and do his own analysis of. Then it has the PDF, which could be in the tens of thousands of pages, right? So those pieces work fine if they are transferred fine, right? And I was always under the impression that if we were downloading them, and I'll explain this a little bit better in a moment, I kind of got myself out of order. That's where we were having issues, right? I thought it was in the uploading and the downloading, because it's often provided to us. The state will send you, the attorney, an email, right? And within that email will be a link to evidence.com, right? And you have like 5 days to click on that link.
Well, they started extending it now. Sometimes it depends on how they send it. It could be a couple of days, it could be a year, it could be a couple months, but it'll have a deadline set on that link. So,
okay. So when you get that link, I'm going to show you guys exactly what we see. So we can't log in and see the case, right? You can't log in. Yes, Afton, you are correct. The state can't, or I'm sorry, the state has an accountant. They could kind of log in, right? What I didn't know, Scotty, did you know that some of the law enforcement agencies use evidence.com as their case management software?
I didn't know that, but a part of me, I had some ideas because one time I'd gotten discovery from the state and it was nice and neat and it was all phone data. So it was like one file specifically for videos, one file specifically for phone data. And I asked the state attorney and they said, how we give it to you is exactly how we get it from.
Oh, wow. Okay. So I'm going to show right now what happens normally, right? And we're going to listen to some of this hearing, because wherever I can, I always want to try to take what I have told you guys about, like in the abstract, and show you in concrete form what I'm talking about, so that you have a better understanding. And so when something like this hearing for Jared Bridegan and Shanna Gardner, when it pops up and it's so relevant to something that I have been talking about for so long, I want to share that with you. So I'm supposed to do this, I think, later in my presentation, but I just want to show this to you now, because this, hopefully you guys can see this. Go share. This is what we get, right? So
yeah, except it ends up being like Russian nesting dolls, and you open one, and then it's
right, because
yeah, there you go.
So this one, but you're right about the Russian nesting dolls, and that happens especially on my federal stuff. But you can see here that this one at least is just JPEGs and PNGs, which is also photos. So this is when we get an evidence.com link and you as the attorney go on there and you click that link, this is what we get, right? And as you can see, it just says created 1 of 2, created this date, and a row of numbers. So this was made 10 or 8/10/2023, package 1 of 2 and 2 of 2. And this isn't telling you how big they are, but trust me when I tell you they are big, because I just spent the week trying to manage 4 terabytes worth of data.
I think you spend half the time trying to organize it. That case we have with the kid with 7 cases, his discovery was and still is kind of a mess, and half the time is spent trying to organize it, and the other half is actually trying to go through it and find out what's relevant, what's important, and actually reviewing discovery.
Or and trying to figure out what is missing, right? So you and I run around. This is just an external hard drive. If this one, you probably can't hear it. The disk in this is loose, the platter that spins. So this is 4 terabytes of information I cannot access because it's broken.
Oh, I had one crash in December, so.
Exactly.
Yep.
So we have this situation, right, where law enforcement and the state use various cloud services. We use various cloud services, and for example, I have one attorney who uses Google Drive, so I have to sign in there to pull all the stuff and to upload all to him. You and I share using Proton, which is encrypted, which doesn't like sometimes the uploads and the downloads because of all the data. It tries to encrypt it all end to end. Exactly, Barry Adams. How would you know what's missing? And so exactly, you don't know at all. This is exactly at 100%.
It's kind of side by side, looking at the note of discovery, which lists everything,
right.
I get, and then looking at sometimes it'll just say it has X amount of photos. You have to go through the photos. Some of them are duplicates sometimes, so you don't really know.
Triplicates.
Yeah.
100%.
So
And
you could be a couple photos off, or you could be more than that. So
Chris, all of the things. And so this week so right now I have 2 of these external hard drives. I think one is 5 terabytes and another one's maybe 4 or 5 terabytes plugged into my computer and networked to where I can access it. I got a federal case. I have one that's a Ponzi scheme. I don't even know what this one is. It takes up the entirety of a 5 terabyte hard drive. And it is, especially when it comes from the federal government, it's a string of numbers for every file. You have to go in there and open every single solitary document. Now, the federal government does provide an index, which is a PDF, an Excel spreadsheet, but it tells you what's supposed to be there. I'll have to find like an old case that I can actually explain it. But the federal government at least tries. So what we're going to do, you guys, it is like looking for a needle in a haystack, but you also don't know what you're looking for. So we're going to play I'm going to put it on. You can't, Barbara Ellison, you cannot put this kind of information into Chat GPT. Like you just can't. I mean, first of all, that loses all forensic integrity if it was ever there to begin with. Hey, only fan, nice to see you. But yeah, no, Chat GPT is great for a lot of things. Dealing with forensic discovery in a capital trial, yes, Junkie, yes. That would just be that would be not so great. So what we're gonna do, guys, is I'm gonna share this footage. This was a 2-hour hearing. I've gone through, Alexis and I went through this and worked on cutting it down. And I'm not going to play it on slow speed. I'm going to play it like on I'm going to try 1.5. If that's too fast, y'all let me know. Put it down to 1.25. And I've got timestamps, and I'm going to pause because I want to, be able to sort of explain as I go. But I love it when Carolina, in my dreams, itemization would happen. Yeah, it just, you guys, like I said, I try to bring you like actual examples where I can. But of course, because what I do is privileged, it's kind of hard at times.
Even due to the voluminous of the discovery, you and I have problems trying to exchange discovery with each other. So
yeah, well,
yep,
that gets addressed in this hearing too. So let's go to the hearing instead of me just rattling on endlessly. And you guys, I'm getting better. I think I just jinxed myself, I'm sure. I'm getting better with the presentation stuff. So yes, Barbara Ellison, Shanna Gardner is the one where the ex-husband had to stop his car to get a tire out of the road. Tanika is diving into that case. And I'm not sure if Trial TV Live is going to stream it or not, but let's take a look here. Let's see. I just jinxed myself. I know I did. Here we go. Okay. So I'm just going to pause and talk, and I've got some different timestamps. So here we go.
Are in the process of going through and completing that indexing.
That's a little fast. Let me take that back down a notch if this is still too fast.
Proposal, because I've done it in previous cases where we've had voluminous discovery, is to then provide hard drives.
Okay, so this is case management conference. The judge has come in and she has said, I see that there are outstanding discovery issues. They were actually there, I think, for a motion for sanctions against the state for not providing the defense what they needed. The defense at this point has received multiple copies of files, and they are different file sizes. So like if you go and try to compare not metadata, but like the file size data, it's off, right? And they don't know what they're looking at. And what the state is providing them, what the state thinks they are, providing to the defense is not at all what happens, because on their end, on the state's end, it looks like your PC might, right? With the file folders, and they're labeled, and all the things are in all the places, and that makes sense. When the state, or when the defense gets it, it looks like what I just showed you. So the judges has like noticed that this is an issue. She's called them in there, and she's like, we're talking about this first and foremost. Okay, so that's where we are. And the state is explaining, and I promise I'm going to shut up and let him talk. He's explaining that his solution is to kind of create an index of everything they've provided already, like a list basically, but a tracking list of data, and then new hard drives for everyone. And the defense is like, you're killing us. We just can't. So here we go.
With the index and all the materials in the format that are discussed in the index to both counsels, and then also file and exhibit with the court. So even the court, when we're arguing motion hearings, would have the same index and have the same materials that would be available for discussions during the course of the motions. It was our understanding after offline and off-record communications with counsel that this would be of assistance to everybody. The other request that we had made, because Ms. Stifler was getting requests from multiple parties from both defendants' teams, and then also even receiving communications from defense experts about formats that are being received and things of that nature, that we figured it would be better to create an email box. There was an error in the creation of it, but we've now cured that error. An email.
Did you hear that? They created a special email box, but there was an error in the creation of that, so that's gone now. This is just
box for communications, and then also points of contact, so that we weren't responding to multiple people on multiple sides, so that we would bring some sense of order the best we could. Everybody understands that this is voluminous discovery. This was a suggestion and a proposal that we thought would be the best way to sort of try to bring some organization to it, and we're working towards that effort to do that. And we felt that after discussions with counsel would be beneficial to both teams, to the state and to the court moving forward, so that everybody was a little bit more organized. This is obviously a very discovery intensive case.
Alexis, I don't have do I keep going through till 23? I don't know. So he's trying to elucidate to the judge what he sees as the fix for this problem. One of the major issues here is in terminology, which is, I don't think that they are all talking about the same thing when they are talking about digital evidence. Is that where I start? The next piece? Is that where I go? Yeah. Okay. Sorry, guys. We were throwing this together like all afternoon. So you'll just have to bear with us as we.
Position, it was not. We have concerns.
Oh, right. Hold on. I screwed that up. I apologize.
Okay.
The sound goes in and out.
Was that the defense proposal? You can be
Yeah,
seated.
no, Your Honor.
Use a microphone.
No, Your Honor. Well, and in fact, the first time I heard about it was when Mr. Khalil called me to told me that that's the way that they were moving forward. Because from Ms. Gardner's position, it was not. We have concerns. We have spent hundreds of hours going through what's been turned over, and we have complained about both the organization of the discovery, the file titling of the discovery, the duplicative disclosures, the vagueness in the discovery exhibits, and now seemingly we are going to have to go through every single thing again to make sure that what the state now proposes is the version we will use for trial is exactly what we've already reviewed. And there is no way for us to do that without opening up each file and confirming things like the page numbers match, that they are the same files. I mean, Judge, we don't know what we don't have, and
we don't know what we don't have, right? Does this sound familiar, Scotty?
Sadly.
And the JAC has pretty strict limitations on what they will pay not only me, but also the attorneys. And it does not include opening every single file. Although I have written before in some of my billings, I literally had to click and open every single file and sent them screenshots.
Yeah.
Because that's just, but what he's saying here is we don't find this acceptable because we don't know if, despite the fact you've given us 5 versions of things, we don't know if those are complete. We don't know what else is missing. And that is what you ran into, I want to say not this week, but maybe last week, where the state was like, oh, hey, we have another phone.
Yeah, I ran into it. Yep. At a pretrial final hearing before the jury trial. So
if that's okay, so if they,
and I ran into it again this week with a dash cam video footage that I guess the state said they were going to get from the sheriff's office, and the sheriff's office said, we don't know what you're talking about. We don't have it. But I guess a victim says we turned it over. So now it's lost. And it's a key piece of evidence because it recorded the whole incident. So.
Oh my God. Oh my God. That's on that one thing. Oh
yeah.
Oh God. Oh God. So, and therein lies the problem. The state has all the goods, right? So law enforcement provides it directly to them. And in the Jared Bridegan case that we're looking at here, it's not only Jacksonville Beach Police, it's the FBI, it's the ATF, and the Secret Service. And I can tell you from experience, because I get discovery from the Secret Service, from ATF, from the FBI, and the local police, that is one hot mess to try to sort through. Because again, they have all the source programming, right? It's like they have the magic lens to decode everything, and there's no coherence on the defense end to be able to read everything that they're providing. And I think it depends a lot on the user who is opening that information, right, on their end.
Sometimes we get phone data we can't even open because they have certain software that only they can use it. So
right. On the UFAE files, that's exactly right. So you guys, the point of me going over this with you and to try to explain it to you is that yes, it's happening in karenread, in that they're still trickling out discovery, which is hugely problematic. And I think the video situation over there is hugely problematic. And if you don't know what I'm talking about, there's lots of channels on YouTube that are covering Karen Read and do great recaps. You're not supposed to be getting discovery right up till trial. And you're sure not supposed to be having the state tell you, oh, hey, we had it, but we lost it every freaking trial. Most of my cases, Squeegee says, how pervasive is discovery effery out there? Every trial, only high profile? It is not only high profile
All
trials.
cases.
It's all of our cases.
How big or small.
And here's where you guys need to understand why this is such a problem. Let's say that you are the defendant, right? Yeah, Afton, exactly. You're not supposed to get new discovery after trial. You're the defendant, and your exonerating evidence is on that phone that the state just told Mr. Sinardi that they can't find. That may be the key
Brady video. Yeah.
Mm-hmm. So what if we can't open it? How do we get into it? Well, that's a great question. So there's a larger issue here at play, and there's so much. Alexis is like, you're gonna get too in the weeds with this, and I already have. And
I mean, there's other issues too, where I mean, just this past week, I've gotten discovery for a case I thought was mine, but it wasn't. It was a police report for a completely unrelated case. So
exactly.
I mean,
So
things happen.
Like we have a case from 2018. It's a death penalty case that's set for trial in December. I have been a part of that case since 2018 because I worked at the law office, and then after a year of me becoming an investigator, I went and took the case back again. And Alexis is putting times in for the videos for me so that I can see. We think that okay, so first we thought there were no phones. Then we got a list of 13 different devices. Do you remember this? Because as I was moving discovery around, then the cops found the DVR that recorded part of what happened, but it's the video that we got originally in discovery is the cop's phone recording the TV. So like if one of you was standing in front of your television right now and just recording this, that's what we got in discovery. And so we go back to the state, and it's 7 years later, and we're like, oh, hey, we're not sure we've got everything. So they dump it all again, right? And on one end, it depends, like what you get, I think depends a lot on the user that is pulling it from their servers and providing it to us. So what the state says is, oh, hey, Mr. Sinardi, go ahead and send us a $300 drive, which is, likely to break somewhere along the line. We'll go ahead and put it on there for you, and good luck to you, sir. And now we have this case that's going to trial. As I said, a death penalty case going to trial in December. And because I was trying to juggle space to unzip all that federal stuff I got, I realized just how many duplicates we have of that particular discovery.
Yep. And then they accidentally sent us discovery they had already sent and thought it was new to them. So
right. And then we ended up with 13 different devices, but we had that many devices because it turned out that the individuals involved had committed sort of a mass robbery. And so not all of those devices were really devices. And, it just, nothing, it's about as clear as mud. And this judge, like, I love her. She's my new judge crush. She is conveying that she sees that the defense is upset, they're frustrated, and they're struggling. She sees that. She hears that. She admits she's lost, and she's trying really hard to match what the state says they've given over, and she can't do it. Fala, I don't think so. I wish you know what?
Thousands of dollars it costs.
Yeah. Oh,
With the-
right, because you tried to get it. Yeah.
Yep, I tried to get the one that broke for me in December, and they wanted close to 12 grand. So
Yeah. No, we're not
I'm not.
spending that. No.
We voiced that several times. We've gotten different files that appear to be the same that are not. And I mean, under the law, we have a right to have the discovery, but the manner has been so disorganized with a lack of clarity, as was even pointed out at the last status conference, and what they are turning over, you know, that we're frustrated. Judge Rankin, we're frustrated. I mean, this is going to delay the trial.
So
There's no other way about it.
Oops.
It's going to.
That brings up a point. You know, as attorneys, we're allowed to have discovery, but the rules don't say, you know, what order or, you know, organization that discovery has to be delivered to us. So I think it's just interesting, you know, doesn't say that we have to get it in a nice separate folders and everything. A lot of times it's just a dump of everything, and the state to them says we met our burden, deal with it.
Exactly.
So.
Exactly. Yeah. So like I see sometimes in chats where everybody wants to tune out during the testimony of the cellular forensics person. But you guys, that should be just as compelling to you as blood evidence, as DNA, because this is what is convicting people. And the information that is being gathered about you and that you are leaving as behind you and around you is staggering. And the fact that the legal system is very far behind should be a massive point of concern. So I don't think judges know what the hell they're looking at. I don't think most attorneys do. So the attorneys push it off to the investigators, and the investigators, some people are like, I don't really want to deal with the digital stuff. So I'm not going to look at that. Right. And you don't know what's in there that could maybe help the client. It's crazy. It's crazy. I mean, this judge, Chris, the squeegee of justice, she does expect it, but it should be. It is their burden. Barry, you're exactly right. They brought the charges. They have subpoena power. They shouldn't have to wait for a corporate analyst. You know, this is crazy. Yeah, the deck is stacked. Let me play. Sorry, guys, because I do want to get to the reasonable doubt, and I'm just like, I was just so excited by this, and I don't know that everybody else is.
Position. I don't think it is.
Okay, so hold on. I've got a new timestamp. We're gonna zoom ahead here. And the handsome man in the bottom right hand corner of this video is the squeegee of justice, Chris from Trial TV Live, and this is their footage.
Pull it up, Ms. Day. Or the state can pull it up. Because that's one of the things that y'all wrote that you've been asking for essentially since the beginning.
And Your Honor, which pleading are you referring to? The last pleading of Mr. Tassoni that was filed 2 days ago? Your Honor.
Oh wait, hold on, guys. I see it. Alexis, it got away from me. I apologize. This came in to my attention, like I said, this morning, and I'm still learning the YouTubes, and we didn't have time to cut it up.
Sir, that's just how it works. That's one clarification I wanted to make. As far as
okay, so what she's talking about here, I'm just go right there.
she's raised to me, we've discussed at a discovery conference at our office, some of the platforms of the information for downloads.
Okay, you guys, I want you to listen to this because I just learned something new today. We've talked about Celebrate on this channel. I know if you're a trial watcher, I know you've talked about it. You've seen it in chats. You've seen it on trial. I have talked also on this channel about something called Magnet by Axiom. And that's different than the Axon body worn camera where you see that in the Chiron. So the Magnet does the forensic images of computers for the most part. And I think I talked about that just a couple of weeks ago, about Sarah Boone getting her discovery in the jail, because I had to take discovery to the jail in the form of thumb drives, but I had to learn the Magnet program to show it to the defendant. That was in the Lorenzo case. So now I'm learning something new. You tell me, Scotty, if you've heard this one.
Through Axon or Axiom for the computers are HTML based. So if she opens it, the report goes through a web browser. That's just how it works. That's one clarification I wanted to make. As far as the extractions, we've provided to defense counsel our UFDR files, which they can open through Cellbrite. They also requested the raw data, which I made available to Ms. Day to go to Secret Service and get the raw data for her client. For bias firm, their expert has been contacting me directly, requesting new copies, first original copies, various formats of different data, and I've complied as best I can to give him what he needs. We have our expert, who is referenced in the letter Mr. Khalil sent, who's going to coordinate with bias firm expert, and if Dreiser Hill has an expert as well, to get them the digital data in the formats that they're requesting. So part of it is they're asking me, they're using terms with me like raw data, and I'm giving them what I believe they're asking for.
Okay. Number one thing, this is not what I learned that's new. Terminology. We don't have equal footing on the terminology. I don't think the judge is saying, I don't think that the judge's concept or idea is the same as what this woman from the state, her concept is, as the one from the defense who's asking for raw data. So I think that's a problem right there.
My expert is gathering all these things in one place on all devices to give it to them in whatever format that they're actually requiring. So they have both the readable version through Cellbrite and the raw data itself. I don't know which one she's looking at. It sounds like she's looking at the raw data if that's how it's opening. But we've provided multiple versions in different formats for these things several times.
When you say raw data, you mean like metadata behind whatever?
So not metadata. Squeegee, I see your question. I'm coming back. So Chris is asking us, Scotti, if we were the judge, how would we handle this? I need to get up and turn my air conditioning down a little bit because I'm hot. Give me 1 second.
You're in the hot seat. I'd probably file a motion as defense for an in-camera review, which is, the judge would be able to review discovery on both ends and see if there's any differences or see if the state's withholding anything. Based on, I guess, the testimony presented from the defense saying they don't have it, review the data as compared to what the state has, and I'm sure the judge would make a ruling based on that.
If you were the judge, though, what would you do? I mean, I say kudos to this judge because, one, she's not ignoring that this is a massive issue in a capital case, right? She's trying to wrap her arms around it. Right. She's trying to help solve it. She's like, hey, I have come here. We're pushing all the blame to the side. We're not talking about, user error, this, that, or the other. We are talking about this is a problem. How are we going to fix it?
Yeah, I think that's why an in-camera review is kind of important, so the judge can take a look from both sides and see, is the state withholding anything, see what the state has and see what the defense has, and confirm whether or not there is anything missing. Otherwise, they're just going to keep ending up in court again saying, well, I don't have X, Y, and Z. State's going to say, we sent it to you. And it's just going to be a never-ending process.
It's a never-ending circle, right? And so part of what she proposes in here, I don't think she understands is as complicated as she's proposing. And so I'm skipping through sections of this because it gets even further down into the weeds, and I don't want to bore people to death with what I find is exciting. Yeah, this is Florida. Everything is it's Florida, I know nothing other than how to be a.
That's it.
I went to law school in Florida. I work in criminal defense in Florida. I don't know any different. So when another Florida case pops up and okay, so for people who have been watching Karen Read and they have seen the way Judge Beverly Cannoni conducts her courtroom, she would have come in here and she would have said, you're going to do it like this. And she'd probably say, defense, this is all your fault. And you're going to have it cured by tomorrow morning, and wouldn't have listened to both sides. So I know I sound ADHD. I am totally, and I'm all over the place with this, and I apologize. I'm trying. I have an outline. I'm supposed to be following. I'm trying. The fact that this judge sees the struggle of the defense and is trying to translate that back to the state is huge, in my opinion, because we don't often see judges who are open, right, to hearing things. And at the beginning of this, which we're cutting that piece out because it's not relevant for purposes of this discussion, they tried to bicker with each other, like, your fault, your fault. And she's like, done. Just no. This is what we're here to deal with because this is ridiculous. It's going on 13 months. Excuse me, you guys. I apologize.
That brings up another issue. There's co-defendant, and I wonder just if the defense attorneys talk to each other to try and coordinate and see if either of them had anything different that the other one didn't have. That's an interesting thing.
Yeah, they are. It sounds like they are trying to. They are all trying to work together. They all have experts. Both sets of defense attorneys are privately retained, and that's money, honey. That's a lot of freaking money. And
that's not even counting the experts.
Right. And they are like, we chose not to, we had our expert booked to fly to go and look at the original data. Like, we wanted to see it as the state sees it and let our expert pull it from that, right? Instead of going through the state to the defense, and we're either downloading it and uploading it, or we're transferring from hard drives. But yeah, I totally just lost my train of thought. Let's play the next piece. I'm sorry, I've been like this all day.
That's why we have an expert, but our expert has told us that is not what we want.
Okay.
And Your Honor, I would just add, while we have received several copies of certain devices, oftentimes the file sizes are completely different. So we have no idea if there was a download error, if there are different versions of reports or downloads. We have no confidence that the versions we have are full and complete. We're just wasting our time reviewing incomplete documents that we're going to have to completely redo.
Sound familiar? This is my life, right? It's my job to review all of this stuff and do it on repeat. But tell that to the JAC. So if anybody is here and you don't know what the JAC is that I keep mentioning, if you came from Tanika's channel and you followed the Sarah Boone case, I worked on Sarah Boone. I am a contract vendor for the JAC, which is the Justice Administration Commission here in Florida. That is the agency that funds all the public defense. I do not work for the public defender. I am down a chain of people. When private defense counsel gets appointed as trial counsel, I can be appointed as well. And again, I have playlists explaining all the things about what I do. And yeah, every state has something, similar that funds things. And I have explained it ad nauseum. So feel free to take a look at my playlist and see if there's, and we're working on also extracting sections out of the streams. I don't go back and edit because I want people to know that's okay to come on here, be yourself, make mistakes, do all the things. But we are working on pulling out sections where I actually say something coherently, and setting those up in the shorts and stories section of things. Philo says, same, I feel you. You or me trying to have a conversation, let alone when I'm excited, 8 trains going in different directions, but headed to the same station. Yeah. That's kind of, I apologize for my craziness. Let's see. Okay, so let's find the next timestamp here. Okay. Oh, that's close-ish. A little hard. There we go. All right, we'll try it from there.
Is that not how it looks for the state?
It's not how it looks for me, but I cannot change the file names of these documents. Some of these are the electronic documents, because that would be changing the original name.
Pause.
Also, by the way, so Judge Bev has the same color Yeti I have, and so does I think her name's Miss Day. I'm not sure. I need a different color Yeti because I'm over it right now.
A moment. So this screenshot, and I'm looking at 16, Exhibit C, okay? Now I'm looking at 16 and 17. So let's start at 16. It has a series of file folders, right? And then it has a bunch of like various file types and MP4, which I'm assuming is some type of audio, and then a bunch of PDFs.
Yep. And if we want to know what that is, right, we have to open it, determine what it is.
And sometimes the opening, that's what you're saying. Is it a zip or unzip? Like
We download it as a zip. We have to extract it. When we extract it, this is what it looks like. And then, for example,
Okay, when he's saying this is what it looks like, they have filed a motion or a pleading of some kind that has a screenshot, which is basically very similar to what I just showed you. We can't see it. Like, you have to be registered to be in their docket, and I'm not registered to be in their docket. So that's why I showed you guys the, and I can show it to you again, the magnet or the, hold on, let me get to the other tab. Sorry, come back. Where's that? Yep. If I didn't close it. Did I close it? Nope. Here it goes. All right. I'm going to share this again. All right. This is what he's talking about. So the state is saying all the files are labeled like witness XYZ and, subpoenas and crime scene photos and blah, 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 blah. And the defense is saying they took a screenshot of whatever it was they got, which I'm taking from the context of this hearing. It looks a whole lot like this, right? So we click and down we go. And if you look in here, okay, it's telling me dates, and then some of it's got a -2 after it, but I'm not 100%. So like here, I've got a file. It's 928_pm.jpg, and just above it is the same thing, but the number 2, which would say to me, okay, that's a duplicate. But and the fact that it's numbered the same over here, that also says duplicate. But if you are dealing with someone's life, do you want to be the person that gets that wrong and says to the attorney or to whomever, yeah, I deleted a whole set of files because I thought they were duplicates? That's the fear I live with, which was what was stressing me so much this week, because I was having to make choices because I didn't have enough drive space to get all that federal stuff okay, I'm just going back to sharing the thing. Let me see.
For example, if I want to know what 2024-1031-105-123_104-282-212_7, I have to open that. I determine what it is. I then have to do a save as, create, if I want to remember, like if I want to find this at a later date, right? I have to do a save as, save a duplicate copy in my own files that this is the transcript of the January 13th 10 inquiry.
Okay.
And then the amount of space that takes up, because again, he's saying, I don't want to miss anything. I don't want to make a mistake here. And that's the thing. Like, I don't want to make a mistake. I don't want to be the one that's responsible for losing, discovery. And then, like Scotti said, the law office had a hard drive crash and all that stuff went off. And then, like I lost everything that was on this drive, and I don't have $12,000 to fix that. Who did I lose? Did I lose somebody? Okay. Let's see. Let me go back.
Defendants.com folder into one, and we'll remove access to Jacksonville Beach Police case management system for their entire police department.
So what she's offering here, she's saying, well, Judge, maybe what I can do is allow them access straight into evidence.com, but that's also Jacksonville Police's case management system. And so I would have to figure out how to not let them access everything else. Like, it would just be limited so that they could come in and see what I see. And I think we missed the part that was where I learned something new today, which is where we've got the Cellbrite and we've got the magnet, and now we have Ivy for the car infotainment centers, and I've never heard of that.
Who manages this system? Is Jack's Beach or like whatever this web service is?
Evidence.com is how we receive evidence from some law enforcement agencies. They use it as their case management system. I have an account to access this particular case file in their case management system and to share files with defense counsel. I don't have authority to share access to evidence.com with them because it's the Jacksonville Beach Police internal system.
I'm not suggesting that.
My suggestion is perhaps there's some way I can do this by creating a mirror of their files on my account and sharing it with them with limited access so they can't get into Jacksonville Beach Police case system. Not that I think they.
Okay, so are you guys getting the gist here that there is no good answer, right? This is a hot mess. And part of what I think is the problem in this particular scenario, and actually probably across the board, is terminology. And without defining some of this terminology, you just don't know if you're all talking about the same thing. And I think that that's why the defense provided a screenshot in their filing, like, Judge, this is what we get, and this is why it's a problem. And I think that that's really important. And what I think is happening to some extent with lawyers, and Scotti, you correct me if I'm wrong, but I think that they are just like, the state's afforded all, the experts and the software and all the things are almost like in-house for them. Whereas the defense, when, say, one of the attorneys that we know that's somewhat older, they get this stuff and they're like, I don't know what to do with it. So they dump it off on their investigator. But what if their investigator doesn't find this stuff as interesting as I do, right?
Exactly.
But I'm still responsible for my own education, and I can't get trained the same way law enforcement does.
Well, I mean, older attorneys don't even know what to look for at that point, especially with the new tech, digital evidence and everything. So
crazy. You can't keep up with it all. And there's supposed to be forensic standards, but when you have everybody coming at this from a different approach, for example, I use Mac computers, which was part of the issue I had. So I got this big federal case, and I mean big federal case, right? That the federal government is not going to pay for. But I got this big federal case. I went to the attorney's office. He gives me an external hard drive that is not broken. I use Mac computers, Apple computers. So I learned a while ago that if I want to be able to work in and out of an external hard drive like this, I needed to format it both on a Windows computer and a Mac. There's a specific process, right? So because I knew that, it took me a little bit, but I did figure out that the reason why I couldn't unzip a file was because the hard drive had been formatted on a Windows only situation, and I was trying to unzip it on a Mac. And I was thinking it was like I couldn't do it because I couldn't move stuff around. Then it dawned on me. I was like, oh, put it into a Windows computer, unzip it and put it back over so that you can continue your work. So that's eventually what I did. But what if the investigator who gets this for the attorney, and the attorney's relying on the investigator to go through this, what if that investigator is like, I don't think you gave us the right stuff, and you're going to try to go back to the federal government who doesn't like to provide stuff to begin with and say, hey, my investigator can't open your file. It's not that the file was broken, it's that the investigator didn't know that there were file format issues. And that's what we're seeing a lot of here. And the judge is trying to explain that because she grasps enough of it to understand that what they're looking at is not the same thing. And yes, you guys, I'm gonna go live with Tanika tomorrow and do some dramatic readings, and I'm so excited. Okay.
That's the evidence that Jacksonville Beach Police has in their possession, that I have in my possession. They have access to download it. We ensure that we all are looking at the same evidence.
But you're not. You're not. And that's what's creating the problem. And it might be usable for you and law enforcement. It is not usable for the defense. They have been saying now, I think for about 13 months, that they are getting this, and that is not usable. It, and also for court purposes, for record purposes, it is not corresponding to what I couldn't make heads or tails of this, to be honest with you. Like, this list is wonderful that is on the back of this exhibit listing all the evidence, right? But it doesn't correspond to anything. So, and I understand that you all want to index, which I think is great. Okay. If you all were working along the same lines and you could say on state's exhibit, whatever, this and this, but they are looking at numbers. And unless you know what numbers they have, there is no way for you to properly index it for review where everyone is working off of the same thing. That is what I'm trying to explain. So what I want, and by the next court date, I want the defense to identify the problematic, electronic files.
Okay, this is a problem. I think what she just said was fantastic, right? She's like, you're not hearing the defense. This is what they're seeing. They're not seeing the same thing you're seeing. But here, this is where I think there's an issue. Judge says problematic electronic files, but doesn't define what that is. And that's a problem, right? We all know what a latent print is. We know what touch DNA is. We have a lexicon, is that the right word, lexicon? A vocabulary for these things now. With the tech, we don't. And I think that this is a problem right here.
And how many versions you all have. To the extent, and you let me know if this is a problem, but because I'm working in an unfamiliar area, right? So if there is a problem with you all duplicating what they gave you, not anything that y'all, like your work product, right? But what they gave you, you could duplicate it back to them. And then once the state has the problematic evidence, then I'm going to meet with you all, and you can give it to.
What is problematic evidence? That's a problem. That right there is, she's trying so hard, and I give her all the kudos in the world, and I hope we see more judges like her going forward. But what is the problematic evidence?
I'll give you some time. You give it to the expert, okay? And I need to know from whatever law enforcement or whoever, whatever, is able to review it. And I want to know how it is going to be communicated back to them. The way that is communicated back to them, that is disclosed back to them on black and white paper, will be what it is going to be, So that would ensure, hopefully, that what the state is saying is going to be what will be in this case, period, end of story. Not some cloud manipulated user error download. And I want to know how big it is or whatever. And if you need to bring these people in, explain to me how it can be disclosed to them in a way that we can all be confident from this day to the last day that it will remain the same. That's what we're going to do. Okay.
I understand, Your Honor. And looking at this is the first time Exhibit C, I'm seeing what they're seeing. So
I know, but they've been saying.
So she's stepping in. She's like, okay, I see there's a problem. And even though these people they say they have sat next to each other and tried to transfer from computer to computer, it's not been working. But I love that this judge has stepped in here. She's trying to offer solutions. She's not blaming anybody. She's not forcing anybody to do anything her way. She's just saying, let's get this sorted out. It's important. It's a capital case, and not just for purposes of this trial, but for purposes of going forward. There has to be a record, and it has to be clean.
The same thing.
Well, and Judge, I think one way we can do this, and we'll work towards this effort once we receive the problematic list, that's adding another column to our spreadsheet of our index. So we're going to have all that, and then we're going to have their identifying factor corresponding with what our corresponding
Perfect.
factor is.
Okay.
That's
So
really,
I mean, when y'all are looking at these numbers, do y'all have it cross-reference, or are you just doing what Mr. Carodi said and just changing it to whatever y'all remember it to be?
Change it, but also, as I said many times this morning, because
I can't hear you, Miss Day.
because we have received so many duplicates, and not just true duplicates, but partial and reorganized and relabeled. It's not just necessarily, we download this from evidence.com. I identify this as report supplement 152 and label it as such. I then have to go back through what we have already saved, download, and reorganized to see if it's something that I already received.
Let me ask.
That is the truth right there, right? That is the truth. Let me check in with the chat here real quick. Yeah, so Alexis is like, this is it. So this is the first time the prosecution, it actually understands that they're seeing what the defendant receives. And I just have been around in this spiral so many times, Scotti, even before you came along. Susan B., I'm having notification issues too. I don't know what is going on. I sometimes get notified that Tanika's on, sometimes I don't. And yes, I'm excited to go on Tanika and do some Sarah dramatic reading. It should be cathartic and therapeutic. How do you preserve the record? Don't move on me. How do you preserve the record with so much digital evidence? How would it be presented to the appellate judge? Hand over terabytes on external drive. Well, so they're not responsible for reviewing discovery. They can only review the trial record. So what's in the record, what's entered as an exhibit, right? What is listed as evidence, defense's exhibit, state's exhibit number, whatever, that's all they can look at. They can't, they're not going to enter, Scotti, am I right? They're not going to enter an entire phone extraction into evidence.
No, they pick and choose what they want, usually by
Right.
date timelines and things like that.
Right. And I showed you guys, and I'll do it again. I'll get the Cellbrite stuff out and we'll look at it again. I didn't want to get too far down that rabbit hole because I didn't know if people would be interested in it or not. But actually, that stream did pretty well. So maybe we'll go back and revisit that. Okay. How can this be the first time it's a prosecution? Well, so, right, Tanika, but they said that they do sit down with each other and that they have like tried to transfer files back and forth, but I don't know that they ever sat and looked at what the end result was. Like what I've just shown you guys, right, from my screen, what we get. I don't know that that's ever happened. I still haven't gotten to reasonable doubt yet. I need to move this along. Okay, so we've got 2 more clips here. So you guys, when you see, if you're lurking the YouTubes and you guys see stuff like this, email me or come over to my channel and leave a comment so that I can go and check it out, because I actually learn a lot from trials. The Seminelli case that Trial TV Live has been following, Chris texted me one day. He's like, hey, you might be interested in the in this expert. And I actually really want to go back and watch that guy again, because this is like school for me to some extent.
Somewhat on the same page, but not totally on the same page. And that is, in this court's perspective, very bad. Okay. Very bad, because evidence has to be what it is. And so like if people have multiple versions of something, there's no reliability in what is being put forward. There's no reliability in what they were spending their time on. And so what my thought is, and what is so important, especially in a capital case, that it is what it is. And so like, that's where we got to get. We are not there yet. I don't think we're necessarily far off. And that's why I want the defense to put your, not in, but like orders to compel, like, so that it is specifically identified what these problems are. And then I'll get to whatever else y'all want to litigate, but like, so that I have like kind of a clear understanding honed down into what actual electronic files / electronic evidence is, where are the multiple versions, what, that listing, so that I can order responses to it in a timely fashion that does not frustrate the path of this case. So that's why, like, starting all over, I don't necessarily, some of this you are going to have to, but hopefully it will be just on a few things, maybe, not totally. Okay. All right. So how long is it going to take for y'all to do that?
Okay. So Alexis wants me to use this analogy we came up with. So you have a file cabinet, and if you're an attorney, and particularly an old school filing cabinet, I have piles. I don't have anything cohesive to show, but you have your files all labeled and organized in the way you want, right? So we're using the analogy of a physical filing cabinet with actual papers and files in it. So just the state thinks that they're kind of passing that along, right? But what's happening in reality is they pull out the drawer and they're just dumping it. And so it's all just paper sort of mixed together, and then they're handing it over. That's the equivalent of what is happening here. So I've got one more clip, and then we're going to finish our jury duty. Let me just thank you guys for indulging me on my geeky love of the tech that I will never ever master. This is and I just want you guys to hear this because again, the Karen Read case is so very much in the news, and I know everybody that there's a lot of people who are very much tired of hearing about it. But the legal shenanigans going on over there are just insane. And the way Judge Canone runs that courtroom and makes her rulings almost, it seems sometimes in a vacuum. Listen to how this judge talks to these lawyers.
In time, I'll put it in order. So then there's some teeth behind it. Okay.
Yes, sir.
Perfect. Thank you, Your Honor.
I mean, I'm operating a little bit in the dark because I don't know what these things are. I don't know kind of what it takes, but if you all I appreciate y'all's patience with me because I'm trying to understand it, but as to the extent that this court can help kind of unravel some of these issues, I'm happy to do that. And y'all, what I do intend to do from this hearing is designate this as a priority case. And as a priority case, it would take precedent over anything I have on my calendar. So if you all need me, I will make myself available at a drop of a dime. Okay. So there it is. Courts, actually the chief judge has made this a priority case. I will incorporate that / memorialize it in order so that you all know that if you need me, I will be here. You will have the court time. I don't want these problems or miscommunication or whatever might be occurring to fester for days and days and days. If y'all get to a meeting and you can't get it resolved, you can have time with me the next day. Okay. I do not want these things to kind of go like this. We need to, and to me, it takes maybe sitting down, hashing it out, and then I will intervene if I need to. I'm not going to intervene if I don't need to. So I will do that so that you all know whenever you need this court, I will be here. Okay.
Hallelujah. Gotta say, love that. Have you heard a judge talk like that?
Not that reasonable.
Right? I love her. Love her. She's going on my list. All right. So I find this stuff really interesting. I want you guys to understand as much as you're interested in it, that there are some complex issues, and it's not just lawyers fighting lawyers. There's some really serious stuff going on in terms of information that is being used to convict people and maybe exonerate people that is very misunderstood, that there does not seem to be one standard for, at least not at the state level. And we don't even have the right language to make sure everybody's on the same page. But so okay. I didn't know about the Ivy platform for car downloads, but I have a feeling I'm going to learn about it the hard way. Yeah, Squeegee says, I love how we can compare and contrast judges and lawyers across all the trials we watch. Yeah, I mean, I can't watch all the trials. I dip in and out as I can. I'm following some of the Karen Read stuff because my jaw's on the floor. And so, yeah. All right, let's move on. Thank you guys so much for hanging in there with us. Could you leave your latent print on the like button or your DNA? And maybe think about subscribing, because that would be awesome. All right, so this is going to be the fourth installment in my Judging the Jury series. We dipped out to talk about the death penalty briefly with Tanika, or maybe that was my third video. I don't know. But we're gonna, this came to my attention, I don't even remember how, but it's the concept of reasonable doubt, which is not just a concept, but something really freaking important. And if you are a trial watcher, which I'm not even calling people anymore like true crime junkies, I think there's categories, right? So I think that there are true crime junkies that want to hear about the case that aren't watching the trial or the motions hearing. I think there are trial watchers, which is what we have a lot of here on YouTube. I don't know. So we're going to look at the meaning of reasonable doubt from the Karen Read trial and the meaning of reasonable doubt, or the interpretation of it, I guess, jury's understanding of it, with Alec Murdaugh. The reason why I picked those two cases is because they have some similarities. Karen Read was tried in Canton, Massachusetts for the murder of her Boston police officer boyfriend, John O'Keefe. Canton is a small community. Many of the people involved in the case know each other well and are local law enforcement. John O'Keefe died on the lawn of another Boston cop's house, and that cop never even came outside. One of the state police has now been fired for his misconduct. It was a mess, absolute mess. And after 16 hours of investigation, the lead investigator, Michael Proctor, decided Karen Read had done it, and that's it. And it's just she's getting ready for retrial. Karen Read did not take the stand in her own defense. She's not required to. Let's compare and contrast that to Alec Murdaugh, which was about, I want to say 2 years ago now. Murdaugh was a very prominent attorney in South Carolina in the Low Country. He was part of what people have called a legal dynasty. He, like his grandfather and his father, were the elected solicitors, which were prosecutors. He worked as a part-time solicitor, not sure how that works. He was tried for the murders of his wife, Maggie, and his son, Paul, who were brutally shot to death. The trial lasted 6 weeks. It was in Colleton County, South Carolina. The state law enforcement division, South Carolina Police, was the primary law enforcement agency investigating the deaths. In Karen Read, it was the state police as well, because the local law enforcement had to conflict off. Alex did testify on his own behalf, and the jury found him guilty of the murders, and Judge Newman sentenced him to life. Karen Read was declared a mistrial. We're going to take a look at that. But immediately after Murdaugh, a number of jurors, members of law enforcement, and the prosecution all gave very lengthy and detailed and professional interviews to the press. Those interviews were insanely enlightening, and I'm so glad they gave them. Thus far, only one deliberating juror from Karen Read's case has spoken to the press. Although, and we watched a clip of him before. So often we're going to be looking at Ronnie again really quick. So even though there's only been the one, that Ronnie, who is thus far has spoken to the press, several reached out to defense counsel and then provided affidavits saying, hey, we cleared her on 2 of the 3 charges, but the judge didn't provide clear enough instructions to let us know that we could split our verdict. And oh my God. So Karen Read's going back on trial. The confusion in the Karen Read case can maybe be attributed to 2 different sources: to the reasonable doubt standard contained within the jury charge and the jury instructions concerning completion of the verdict slips themselves. So proof beyond a reasonable doubt is the highest legal standard. It's what the Constitution requires. It has been this way for a really long time. But here's what I need you guys to look at. If you've got a screen in front of you and you can look up, I want you to check this out. Okay. This is a side-by-side of Karen Read's jury instructions with Judge, I'm so sorry. So the long one on the right is Judge Cannone, is Karen Read. The shorter one on the left is South Carolina. So the state must prove the defendant guilty beyond a reasonable doubt. So what is a reasonable doubt in the law? A reasonable doubt is a doubt which makes a reasonable, honest, sincere, and conscientious juror hesitate to act. Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. Proof beyond a reasonable doubt can also be described as proof that leaves you firmly convinced of the guilt of the defendant. Now, there are very few things in the world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of a crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. That is Judge Newman in Murdaugh. How do we feel about that? Barry, are you the only one left to chat having a conversation with yourself? Did we run our chat off? I don't know, Scotty. I may have bored them all into tuning out. Okay, so I'm going to keep going, though, because I find this interesting, and maybe somebody, well, Barry's with us, right? If we've got Barry, if no one else, we've got Barry. So here, what we learned in researching this for the reasonable doubt part, Scotty, is that Massachusetts is using language from the 1800s.
She's really mad.
See, Morales is here. Thank you. Thank you. Afton says jury instructions are fascinating. So I will admit that, like, I kind of tune out when they go over the jury instructions. I had not been paying attention. It was one of those things I sort of, I sort of take for granted, right? But you can see on the left, reasonable doubt, like that. Hi, Mel. Okay. Thanks, guys. Yeah. Let me know you're still here, please. Scotty and I have these conversations while he's in the car, and now I'm here trying to explain it all to you guys. So I think that if I I'm so glad, OnlyFan, thank you. So if I was on the Murdaugh jury and I heard that, that would make sense to me. Would you agree with that, Scotty, what I just read?
Yeah, and nobody explains it, so as a juror, I would be more confused than when I walked in.
Okay, but wait, there's more. Okay, so that was the South Carolina one. Here's Massachusetts. Well, this is Bev's. I listened to her or to another judge in the same county read jury instructions the other day, and I'm not sure it was all the exact same. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all reasonable doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convict you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. I do not love the word moral certainty. To me, that just makes things way harder. What do you think, Scotty?
Yeah, like I said, it's more questions than answers at that point. And, it takes 3 years of law school to actually understand a reasonable doubt, and even after that, case law, it's kind of a case by case basis. So,
Barry, so on the left on here is South Carolina's. That was directly taken from Judge Newman in the Murdaugh trial, and Bev's are on the right hand side. I did my best to make it as readable as possible for you guys. I think on Patreon is going to be documents and stuff. If you're interested in following or learning more. I found so much stuff I found interesting about juries. Bev's instructions are monopoly box rules, so confusing and fractious people throw them out and do house rules. Well, we know they did some basic math. John plus Karen plus Clara plus alcohol means Karen did it. Bev's instructions are, yeah, hear ye, that's the Commonwealth. Why didn't they ask? Clearly they were confused. I think that Judge Bev, so we looked to see if like her demeanor towards the lawyers in front of the jury was as bad as it is currently, and it wasn't. But I don't feel like she was very welcoming. I just don't know. I don't know, you guys. Barry says they did ask, that's why the case is being retried. Someone said they wanted to ask, but Foreman wouldn't let them. I don't know if I buy that. Ken Rosenberg. There was a law review article from a while ago that polled judges on what value they assign beyond a reasonable doubt, and the answers varied from 70% to 99%. Oh my God. What even is a moral certainty? Thank you. Okay. So yeah, we're going to listen to Judge Newman. I'm sorry, Alexis. I mess up my outline. She doesn't like for me to give her a lot of credit, but I have very detailed and a lot of work goes into this, and then I go off on a tangent. So yeah, we're gonna listen to clips. I'll stop talking. Let's see. I think I read what Judge Newman is supposed to talk to you guys about. Hold on, let me see. I have to go over here. We are learning all the things. Okay, let's go there. Go back over here. Oh, nope. We're sharing that. That one. Share. All right. Judge Newman.
I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt.
That seemed to make Alec a little bit nervous. So in Murdaugh, the jurors were able to reach a unanimous decision. He was found guilty of 2 counts of murder and 2 counts of possession of a weapon during a violent crime. In the next clip that I'm going to show you, one of the Murdaugh jurors, James, who, if you were with me, I think 2 or 3 weeks ago, we looked at James versus Ronnie, decided who we wanted to be on our jury, right? So this is going to be James explaining how they came to reasonable doubt. Hold on, I might not be sharing. Am I sharing? No. Try sharing. Here we go.
I think more so than somebody being dead set on one thing or the other, we all, I think, were very good in taking all the evidence and not jumping to any conclusions, but rather taking all the evidence and seeing where it led us. Whenever we got to the end and there were some people that weren't convinced, I don't think it was so much that they knew that he was not guilty as they just weren't sure yet. They might not have known answers to certain questions. So that's when it really took that 2 hours to kind of walk through something they might not understand, go back to the evidence, go back and see what somebody said about something, and answer those questions for those people. Like I said, it wasn't that they knew that he was not guilty, but they just weren't sure, and they needed the answers to those questions, and we were able to get those.
Okay, so we like James, the juror James. He we're gonna you've heard him there. He said it took them, they were only out for 3 hours. I texted you that night, or I called you. We hadn't even known each other very long, and I had been following this trial, and I was like, I called you. It's like 8 o'clock at night. I'm like, there's a verdict. I can't. Oh my God. Yeah, I didn't have anybody else to call and say, oh my God, can you believe this? Let's look at Ronnie from the karenread jury, which was out for days. Ronnie expresses his belief that the evidence, at least the evidence he decided that was worth considering, proved that Karen plus John plus Car equals dead John, thus Karen hit John. And he interpreted the defense case as presenting distractors. Okay. The defense's case, he called distractors. That's a problem. That's a really, really, really big problem. You guys, big problem, big, huge, huge, as Julia Roberts said in Pretty Woman. Go back. Yes, I know that's the wrong one. Go to the next one. Okay.
Okay. I'm a nurse, guys. I see this all the time. That's not consistent with motor vehicle collision.
Correct. I think we were all kind of saying, no, that doesn't seem, that is not consistent based on our experience on the damage to the vehicle and the injuries that Mr. O'Keefe sustained.
All right. Next question here. We have, this is from JJ, sends $10. You said you guys came to the conclusion, or that some jurors came to the conclusion, that she hit him because she was there, he was there, and there was some kind of collision. If the defense did a better job at explaining that he wasn't hit by a vehicle, would that have changed your thoughts? Or if they focused on John sustaining injuries inside the house instead of from a vehicle? I don't understand the second part of that question, but I guess my question that will go along with this is like that. Do you think that they focus too much on the conspiracy aspect of what happened and not enough just on, look at, dude, there's no way this guy was hit by a car because that's what the science says?
I think that would have been helpful, because really creating the distractors, whatever distractors that may be, like he went inside the house, he got injured inside the house. There was the dog that bit him. There was, injury in the weight room downstairs. All of these became kind of like theories and confusing or distractors to the jury. So ultimately, they just looked at the facts, and the facts were there's damage to the vehicle, right? So a simple look at it is, two individuals were there. Somebody was operating the vehicle under the influence. There's damage to the vehicle. It's a broken tail light. There's injuries to John O'Keefe, and now he is dead. Then who's ultimately at fault? The operator of the vehicle.
And there you have it. Does that not disturb you, Scotty? Because it disturbs me.
Yeah, these are the people that make the decisions on people's lives. And
he's calling the experts that gave very detailed explanations of how it's mind blowing. So, okay. And karenread's jury, they were out for, they were sent to begin deliberations on Tuesday afternoon. They continued to deliberate for 3 full days, Wednesday, Thursday, and Friday. They communicated their difficulties to Judge Cannoni in 3 notes. So I'm going to show you the notes. Here's the first one. I have the slider open and lights are attracting little bugs because I have Henry outside, so he won't bother me. Okay, so this is the first jury note. I'm writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Okay. So Adam Lally, the prosecutor, says, Judge, simply hasn't been enough time yet. The note doesn't really indicate affirmatively that they can't come to a conclusion. It just says they haven't come to a conclusion through their deliberative process at this time. Judge Canoni responded that in light of the amount of evidence presented during the 10-week trial, she would like the jury to continue deliberations. So she told the jurors, lunch is coming. When it comes, I'd ask you to clear your heads, have lunch, and begin again. So they resumed their deliberation. They were sent home at the end of Friday, told to return on Monday. Okay, Monday. Here's note number 1. Judge Canoni, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of these admissions and the implications it holds. Does that sound like Ronnie? Okay, so first of all, put the pieces together. Ronnie is on this jury. The person that wrote this note is on the same jury Ronnie's on. Does that make sense to you? It blows my mind. It blows my mind. Okay. So after this note, Lally says deliberations need to continue. And the defense says, offer the Chuy Rodriguez deliberation instructions. Do you guys know what that is? I did not. So, Scotty, have you heard of Chuy Rodriguez before?
No, I haven't.
All right. Well, we're going to learn about it. When a judge feels as though a jury is genuinely deadlocked, Massachusetts allows the judge to issue a special instruction that sometimes is called a dynamite instruction. The Chuy Rodriguez instruction is designed to unlock the deadlock, and it basically urges the jury to go back, really listen to the other side, be mindful of the fact that you're just as well positioned as any future jury would be to make this decision. So after hearing arguments from both the Commonwealth and the defense, Judge Canoni said the following: I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they are now, with the additional time that they went out Friday saying they were deadlocked, is due and thorough deliberation. So I'm going to give Chuy Rodriguez. Due and thorough deliberation means making decisions or acting after careful consideration, thoughtfulness, and a process of weighing options. Because I was like, what is that a type? Like, is that a grammar issue? Due and thorough deliberation. So she gives the jury that that instruction, right? And hi, I rescued dogs. Nice to see you. I read that. Alexis, due and thorough deliberation means making decisions or acting after careful consideration, thoughtfulness, and a process of weighing options. So on Monday, I'm trying to scroll up on the wrong computer screen. There was one final note. Okay. We continue to find ourselves at an impasse. I'm supposed to play a clip. Hold on. I'm trying to do all the presentational things, the YouTube things. Back. I share from here, but we're going to go down here.
Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
Okay. So that was crazy, right? Barry Adams says, he's talking to Afton, says, I copied the jury instructions to AI and my Microsoft Copilot spun for 2 weeks and crashed. Afton says, I did not like how Kanoni told them to go by what she said, not what was written in the case of a conflict. So the language regarding the moral certainty in the instructions is reflected back as moral convictions in the note. Do you think your morals belong in jury deliberations?
No.
Exactly. I think that that's more confusing once you add morals in there. I don't know. I find it to be misleading and confusing. The other thing that stood out to me in this whole situation was the difference of the language between Ronnie's interviews and the notes. And so I feel like the tone and the phrasing and the wording of the note was just way above Ronnie's level. So it's kind of confusing. And then I've got the juror verdict slips, which are really bad. So I'm going to go ahead and skip that. But I want to play one more clip for you guys. If you're still with me, here's the last we're going to see of, share your screen, ma'am. Got one last little
reasonable doubt in some minds. Unfortunately, we didn't get clarification early on that we could look at each charge individually and independently of each other. If we had done that, then I don't know where we would be or if we would be talking today.
Do you think there was going to ever be resolution on that second charge?
I honestly believe that there would not have been any resolution because some people had very good arguments. And at that point, it was just trying to convince people and change people's beliefs, which would not be possible.
And this was interesting as well. After spending so much time together, the 9-week trial.
Okay. So does that terrify you? Because it should.
I think the juror just likes the media attention.
I mean, does he even know what he's saying? I don't think he has a clue. Okay, so the latest development in karenread is that a juror who did not make it to deliberations, was a lawyer, has joined her defense team. Did you know that?
Only from when you told me earlier this week.
I think if that had to make Judge Kanoni's head about to want to pop off because, really? A juror that didn't get to deliberate, was an attorney, got on the panel, and now has joined the defense team. She is not a criminal defense lawyer, so it looks like she's there for kind of jury consultant purposes. But holy crap, like John Grisham could not make up any big of a legal thriller than what is happening over there. Like, I just can't even wrap my head around it. And I know people are tired of her, but it's just like the legal, I don't even know what to call it. The kitchen sink of legal nonsense is what just keeps me sort of hooked into that. So with that, I'm going to remind you that tomorrow, I think we're doing it from 4 to 6 on Tanika's 2 cents. I am going to join Tanika. I'm so honored to be able to do a dramatic reading of Sarah's email correspondence with Lana, who was one of the few people that spoke via Zoom at the sentencing, supporting Sarah. And so I'm excited to do that because I just can't get over. I thought Sarah was really shallow, when I met her. And then she is really shallow, but there's like a layer of evil in there too. I'm here every Saturday at 7:15 p.m. and Eastern time. And you are on the TikTok. And we will see you, hopefully, again. You guys have a safe weekend.
See ya.
Thanks for joining me, Scotti. I appreciate you.
Always like to join. So